Good morning, and thank you for joining us for this important event today. I'm Ryan Anderson, and I have the privilege of serving as the president of the Ethics and Public Policy Center, and I'm delighted to welcome you to our Big Tech Symposium. Good morning, and thank you for joining us for this important event today. I'm Ryan Anderson, and I have the privilege of serving as the president. Sorry about that. Minor technical glitch here. Okay, so as I was saying, this symposium was born out of the Big Tech project that EPPC launched in April. The goal of our project and of our event today is to help conservatives come together to clearly identify and articulate the problems that Big Tech poses to our society and our Republican form of self-government, and to think critically about targeted, constitutionally sound policy solutions to these varied problems. At EPPC, we work to advance the best policies we can to hold big tech companies accountable for their practices that threaten the interests of the American public. And we want to bring an end to big tech censorship of conservative voices and speech. I can speak to this censorship personally. Shortly after taking over as the president of EPPC in February, Amazon disappeared one of my books, When Harry Became Sally. After selling my book on transgender issues for 3 years, Amazon decided it now violated their content policy, conveniently waiting until after President Trump and Attorney General Barr had left office, and Republicans no longer held the majority and committee power in the Senate. Amazon wouldn't tell me or my publisher what page of the book committed the offense, or, at least at first, what aspect of their content policy the book had violated. Eventually, they claimed that the book says something that it doesn't in fact say, and that this is what runs afoul of their content policy. Of course, the timing was, let's just say, suspicious. They disappeared the book the Sunday before the House of Representatives was set to vote on the so-called Equality Act, a piece of legislation that the book criticizes at length. The attempt to discredit me, however, has broader implications. With Amazon's market dominance, future authors and publishers will think twice before writing a book that might run afoul of the Amazon censors, especially if they won't be able to garner any media attention. And of course, it doesn't matter how rigorously and charitably we make our case, as it's not how we say it, but what we conclude that big tech objects to. Beyond censorship, the EPPC Big Tech project focuses on big tech companies' consolidation of market power and potential violations of antitrust law, the ways in which big tech products and services can harm America's children, and the illicit and potentially criminal content they host on their platforms. Just last Friday, there was a ruling from the Texas Supreme Court holding that Facebook can be held liable for sex trafficking recruitment that occurs on its platform. This is an encouraging step in the right direction on these issues, and we intend to hold big tech companies accountable and work to protect women and children from these harms. Now, there's a debate on the right about all of these issues. Are the problems as bad as I suggest? Are there any effective solutions? Can we trust the government to not just make things worse? Answering these questions and more is the point of today's event. As conservatives rightly fear big government, we can't allow that concern to lead us to turn a blind eye to big tech. After all, we regulate businesses all the time. Some are prudent and effective and necessary regulations, and some are not. We need not apply to big tech all of the features of an existing system of regulation that was designed for other contexts, whether it be non-discrimination law, antitrust and monopoly law, or the legal rules for common carriers and utilities. But policymakers need to take seriously the questions of what limits should be placed on the power of big tech. Absolutism about market freedoms is untenable. After all of our liberties have limits. And to take just one example, antitrust law is at the service of making markets work better. None of this is to suggest that crafting good, effective constitutional policy in this space is easy, nor is it to downplay the importance of economic freedom and property rights. It's just to say that while those freedoms are important, so too are other things. The common good is multifaceted, and there's no reason to believe that granting big tech unlimited liberties is how we best protect human flourishing and human dignity. We hope today's event will be an important step in our work building a diverse coalition committed to holding big tech companies accountable and developing policy solutions that realign Silicon Valley's incentives with the best interests of all Americans. To that end, we have brought together a truly tremendous lineup of scholars, experts, and members of Congress who are conducting research and drafting legislation on the issues surrounding big tech. First, we'll hear from 5 members of Congress who will describe the legislation that they've drafted and introduced, what problems they intend it to solve, and how their bill goes about addressing it. Then we'll hear from 3 panels of law professors and other policy experts to discuss the strengths and weaknesses of 3 general approaches to big tech reform: Section 230, antitrust law, and common carrier law. All of the hard work in organizing today's symposium has been done by, and the credit for pulling it off so successfully goes to, Claire Morell, who heads up EPPC's Big Tech Project. Thank you, Claire. And thank you to all of our speakers for making the time to be with us today. Thank you also to 2 generous benefactors who have made the Big Tech Project a reality without receiving any big tech money. Without further ado, I want to introduce our first speakers, 5 lawmakers who will be discussing the legislation they have introduced to address the issues they see with big tech. First, we'll hear from Senator Josh Hawley of Missouri. Before being elected to the U.S. Senate in 2018, Senator Hawley previously served as Missouri's Attorney General. He has litigated at the Supreme Court of the United States, the federal courts of appeals, and in state court. Senator Hawley serves on the Senate Committee on the Judiciary and recently introduced the Trust Busting for the 21st Century Act, intended to address big tech's monopoly power. He also recently published the book, The Tyranny of Big Tech. Next, we'll hear from Senator Bill Hagerty of Tennessee. Prior to his election to the U.S. Senate in 2020, Senator Hagerty served as the U.S. Ambassador to Japan. A lifelong businessman, Senator Hagerty has served on many corporate boards, including NASDAQ and the New York Stock Exchange. Senator Hagerty serves on the Senate Banking, Housing, and Urban Affairs Committee, and recently introduced the 21st Century Speech Act that repeals Section 230 and regulates large internet platforms as common carriers. Third, we will hear from Congressman Ken Buck of Colorado's 4th Congressional District. Congressman Buck was first elected to Congress in 2014 and serves on the House Judiciary Committee and as ranking member of the House Judiciary Subcommittee on Antitrust, Commercial, and Administrative Law. Congressman Buck has recently co-sponsored 6 bills, all of which were advanced out of the House Judiciary Committee last week, intended to update antitrust laws in order to protect consumers and promote competition in the digital markets being dominated by big tech platforms. Most importantly, though, he's a fellow graduate of Princeton. Fourth, we will hear from Senator Marco Rubio of Florida. First elected to the Senate in 2010, Senator Rubio is a member of the Senate Committee on Small Business and Entrepreneurship, and he recently introduced the Discourse Act, intended to hold big tech responsible for complying with pre-existing obligations in Section 230, and to clarify ambiguous terms that allow big tech to engage in censorship. And then lastly, we'll hear from Senator Mike Lee of Utah. Prior to his election to the US Senate in 2010, Senator Lee was a 2-time clerk for Judge and then Justice Samuel Alito. Senator Lee serves as the ranking Republican on the Judiciary Subcommittee on Antitrust, Competition Policy, and Consumers' Rights. He has introduced the Promise Act, intended to hold big tech accountable for the promises it makes to consumers, especially in terms of its content moderation policies. And most recently, Senator Lee introduced the TEAM Act, intended to strengthen antitrust enforcement against big tech by improving the legal standards and remedies under antitrust law, increasing funding, and consolidating antitrust enforcement under one agency, the U.S. Department of Justice. I thank the members of Congress for speaking to us today, and I turn it over to Senator Hawley.
Hey, Josh Hawley here. Thank you so much to the Ethics and Public Policy Center for inviting me to take part in this conversation. I'm really glad you're having the conversation. I think it's really, really timely. When we think about the influence of these big technology companies on our economy, on our lives, and really on our democracy, this has been an issue that has been one I've worked on since I was Attorney General of the state of Missouri. And the more that I've gotten into it, the more work that I've done in this area, the more concerned I've become about the effects on our republic and about what it means for these giant oligarchic corporations. And that's really what they are. I mean, we should be honest here. These are the most powerful corporations in American history, probably ever, but certainly since the railroad barons of a century ago. And they are exercising, as those railroad companies tried to do, the big tech companies similarly are exercising an amount of political control and political influence that is dangerous to Republican government, lowercase r. It's really dangerous, and this is one of the reasons why conservatives and Republicans with an uppercase R were big trust busters a century ago. You think about it, the policy, the agenda of trust busting really was invented by Republicans. It was the populists actually who first really put it on the national agenda, but it was the Republican Party who picked it up and made it a central part of our platform over a century ago. We were at the time a pro-worker, pro-free market, and also pro-trust busting party. That's a pretty good combination. And I think there's a great historical analog, or that is a great historical analog for us that we ought to look to, an example that we ought to look to. And the reason that I want to suggest to you that we should be for trust busting in this new century is because it is market reinforcing. Trust busting is about allowing the free market to actually do what we want the free market to do, which is to support robust competition, which is to support actual control by individuals, by citizens over their lives, but yes, also over their government. And that's why I've come to believe over the years that we need a new trust-busting agenda for the 21st century. And so I want to just mention 3 proposals. I've introduced a lot of proposals on tech, but I want to put forward 3 for your consideration as you have your discussions. The first is, I think we need to take a hard look at unwinding and then banning what I call conglomerate mergers. What I'm thinking here is Amazon, for example. All the big tech companies do this, but take Amazon. It is the combining of multiple disparate businesses under one company, or one quote-unquote holding company. So Amazon, of course, has the dominant e-commerce platform in the world, but they also own a pretty much dominant share of the cloud with AWS, and they also own a grocery store chain, that's Whole Foods. They also have a trucking business. Now they want to buy MGM, and they have all manner of other subsidiary businesses that are nevertheless unrelated to each other as well. There's very little economic benefit, economists tell us, from these sort of conglomerate mergers, but they're also dangerous for competition, because what you can do is you can cross-subsidize from one business to another in order to undercut competitors, get a corner on the market, and then get a monopoly in multiple markets at the same time. And of course, the political influence of these companies only grows as their market power grows. So I think that we need to pass new legislation that will prohibit these kind of conglomerate mergers by these tech companies where they're combining multiple different unrelated lines of business under the control of one company. And so I suggest that to you as something whose time has come, and that I think would make a real difference immediately in terms of stimulating competition and putting control back into the hands of American citizens and American consumers. The second proposal I would put forward for your competition is a limit on mergers and acquisitions for any company, regardless of whether they're in the tech sector or not, if they're of sufficient size. And I'm thinking companies that have a market cap of over 100 billion. If you are that size, then you don't need to be any bigger. And I think that we've got to get serious about the effect of consolidation. We're seeing mass consolidation in our economy across multiple industries. And globalization is driving a lot of this, but American law is permitting it. We're seeing mass consolidation. There's lots of economic data to suggest that this kind of consolidation creates monopsony power in the labor market. It helps keep down, hold flat wages for working class individuals. Of course, it's also bad for competition when you see increasing concentrations of market power. And so for these mega corporations, I think it's time that whether the tech sector or outside the tech sector, that we straight up limited their ability to get bigger and to acquire additional companies or lines of business. So proposal number 1 is to actually break up the different lines of business that the tech giants, Amazon, Google, Apple, Facebook, have consolidated under one roof. And the second proposal is to limit going forward in every sector, to limit truly mega corporations, mega multinationals from acquiring new lines of business and consolidating those. The third and final thing I would put forward for your consideration is Section 230, the famous, now infamous Section 230. I hope that you understand that Section 230 as it currently exists is not the Section 230 Congress wrote back in the 1990s, back in 1996. The courts have substantially rewritten Section 230. I talk about this in my book, The Tyranny of Big Tech, And if you don't trust me, and you want even a shorter precede, go to Justice Thomas. Justice Thomas has a great opinion in the Malwarebytes case where you can see him lay out some of this history, the history of the redrafting of Section 230 by the courts, often with the cooperation of the big tech companies, sometimes at the behest of the big tech companies. And you can see that evolution there, how Section 230 went from being supposed to be a competition protecting measure that would allow Congress to say we need to take down content that is obscene, we need to take down content that is pornographic in some cases. That's the original purpose of the Communications Decency Act, and yet allow these companies to not be liable when they do so. That was the initial idea. Now it's become something quite different. It's become a broad immunity shield for these dominant corporations, and you can see how the courts have rewritten it to get there. My view is we need to allow individuals to sue these corporations when the dominant social media platforms, when they do not follow their own terms of service. It's really a simple idea. The terms of service you and I all agree to open a Facebook account, to have Gmail, you've got to click, I agree to the terms of service. But guess what? They're not enforceable. If Google or Facebook violates those, what can you do? Nothing. That's because of Section 230. I think we ought to make those terms of service enforceable by allowing people to go to court. What good would that do? Well, it's really a matter of countering the censorship and the control over speech, the control over communication that these companies have. They say in their terms of service they don't engage in political bias, they don't engage in political viewpoint discrimination, and yet we all know that they do. I mean, the evidence suggests strongly that they do. My view is that why not allow their own terms of service to be enforceable, and then we'll find out real quick. And those companies will have a massive incentive to actually follow what they say they're going to follow, to actually do what they say they're going to do. And by the way, this doesn't prevent alternatives, conservative-based alternatives, from coming into being, from being founded and competing for market share. So I think this would actually increase the amount of speech on the internet. It would increase competition in the social media realm by holding these companies accountable and making them apply or play rather by the same rules as every other media platform. And if you really wanted to, you could limit that ability to sue. You could say that smaller new startups would enjoy a brief period of immunity from suit, but the mega corporations, the dominant platforms, would not. If you're really concerned about encouraging new innovation, new competitors, and I think that ought to be one of our main goals. So there are three ideas for your consideration as to how we might tackle big tech's influence. I think the bottom line is this. I strongly believe that as conservatives, we have to be for competition and we have to be for popular sovereignty. We have to say that the American people should control their own data, they ought to control their own speech, and they absolutely need to control their own government. And we need to recognize that big tech has become a barrier to all three. Thank you so much for having me.
I want to first thank the Ethics and Public Policy Center for hosting me and for holding this big tech symposium on a very important topic. Americans today communicate with one another and consume information using technology platforms that function as the modern public square. Yet this public square is controlled by big tech corporations like Twitter and Facebook, not a government responsive to the people. Increasingly, big tech is exercising this authority in a way that is inconsistent with the foundational principles reflected in the First Amendment to our Constitution: free speech, freedom of belief, and the open exchange of ideas. In recent months, big tech has removed news that was inconvenient for their loudest users' preferred candidates. They've silenced the President of the United States, and they suppressed politically unfashionable facts regarding the origins of COVID-19, which hampered discovery of the facts regarding the virus's origin when those facts were fresh and were more discoverable. The question is not whether the Constitution permits them to do so. It's whether the law should permit them to discriminate in this way, given the effect that it has on the free exchange of ideas. Big tech is filtering information through its political and cultural lens before Americans get to see it. It's an attempt to control what Americans think. This sounds like the game plan of the Chinese Communist Party, not the United States, and it can no longer be ignored. That's why I recently introduced the 21st Century Free Speech Act, which puts the American people, rather than big tech corporations, in charge of what they say or hear in today's public square. My bill would first abolish Section 230's license to censor. It would treat big tech like a common carrier that must provide reasonable, non-discriminatory access to all consumers to prevent political censorship. And finally, it would require consumer transparency regarding content moderation. As Justice Clarence Thomas noted in a recent Supreme Court opinion, certain industries, known as common carriers, with the function of connecting people and information and having essential status in everyday life, have historically been subject to special regulations, including a general requirement to serve all comers without discrimination. Over the years, these industries have included telegraphs and telephones. Access to a telephone line doesn't depend on what political views you express through it. The same logic should apply today to big tech platforms, defined in my legislation as platforms with more than 100 million worldwide active monthly users. These are today's common carriers. The 21st Century Free Speech Act would also require big tech to publicly disclose its content management and moderation practices to users to ensure basic consumer transparency. So that these common carrier and consumer transparency requirements are enforceable, my legislation would allow consumers and states' attorneys general to address violations via civil action. Finally, this legislation would abolish Section 230 in favor of a liability protection framework that matches that section's original intent. At the behest of big tech and its army of lawyers, courts have stretched Section 230 well beyond its design, which was to promote the free exchange of ideas online and to encourage family-friendly moderation. The 21st Century Free Speech Act would make clear that protection from liability for third-party speech does not apply to the platform's own conduct, either manually or through use of an algorithm. And it would define terms like obscene, lewd, and excessively violent that govern the family-friendly moderation immunity. This would prevent big tech from stretching this provision into a license to censor speech on political, religious, or other grounds. The question isn't whether everything on the internet is true. It's whether Facebook and Twitter should decide what's true. And I believe the American people are smart enough to figure out what to believe for themselves. This freedom to think, discuss, and determine one's own beliefs is the foundation for over 2 centuries of American liberty and opportunity. We must fight to preserve these freedoms. Thank you.
For too long, big tech has been taking a baseball bat to the free market, crushing competitors, buying up innovators, and building an increasingly unassailable position atop the digital economy. Amazon, Apple, Facebook, and Google began as American success stories, highlighting the benefits of free market capitalism and the American economic system. However, once they achieved sustained success, big tech decided to flip the script. The innovation and dynamism that allowed these companies to prosper became an enemy to be bought or killed. Decades of congressional lethargy and judicial misinterpretation enabled these digital kings to transform from exciting startups to hulking behemoths that swallow up every startup in their path. Congress has failed to update antitrust laws to deal with the robber barons of our era, and as a result, courts have slipped further and further from the original intent of laws passed during the trust-busting days of Teddy Roosevelt. I've worked with my congressional colleagues on both sides of the aisle to introduce 6 bills that will update our antitrust laws and deal with the most harmful anti-competitive behavior we witnessed from big tech during our 18-month-long bipartisan investigation. This narrowly tailored approach empowers consumers, protects small business, and restores competition. This legislation, the State Antitrust Enforcement Venue Act, will allow state attorneys general to pursue antitrust cases in the venue where they filed. Big tech has a history of attempting to relocate cases to more favorable jurisdictions, and this bill puts an end to that practice. The Merger Filing Fee Modernization Act will improve funding for the FTC and the DOJ without imposing additional costs on taxpayers by increasing the filing fees for large mergers for the first time since 2001. Apple, Amazon, Facebook, and Google have all engaged extensively in the M&A market to eliminate potential competitors. Similar bipartisan legislation passed out of the Senate Judiciary Committee with support from members like Josh Hawley, Ted Cruz, and Marsha Blackburn on May 13, 2021. The Access Act is focused on empowering consumers and reinforcing private property rights. Users, not big tech, should control the data they generate, as well as be able to use and move their data as they see fit. Data portability and interoperability address this problem by allowing users to control their data and requiring platforms to speak to each other so that this data can be easily transferred when a consumer decides he or she wants to. In addition to benefiting consumers, this legislation eliminates data as a barrier to entry in digital markets and allows smaller platforms like DuckDuckGo and Parler to compete against big tech. The Platform Competition and Opportunity Act addresses the overly burdensome evidentiary standard currently faced by antitrust enforcers. Between 2000 and 2019, the dominant platforms collectively engaged in several hundred mergers and acquisitions, but antitrust enforcers did not block a single transaction. Among the most egregious examples of inaction, Facebook acquired two large competitors, WhatsApp and Instagram, just 2 years apart, cementing its already dominant position in social networking and related digital advertising markets. By establishing a rebuttable presumption against mergers and acquisitions of potential competitors by big tech, this legislation ends their kill or buy approach to competitors. The American Innovation and Choice Online Act prohibits dominant platforms from acting as gatekeepers and favoring their own products or services in downstream markets or economically discriminating against firms to pick winners and losers online. Big tech has engaged in extensive self-preferencing, whether it's Google favoring YouTube videos in its search results or Amazon discriminating against Parler based on political disagreements. Conservatives have seen the end result of this discrimination firsthand, and this legislation prevents it from continuing on an economic or political basis in the future. And finally, the Ending Platform Monopolies Act utilizes the long-standing divestiture remedy to break up big tech. The bill identifies 3 circumstances when a business unit would have to be broken off, including when a covered platform uses their own platform for the sale or provision of products or services, when a covered platform requires a third party to purchase another good or service to use the platform, or when a covered platform's ownership of the business gives rise to a conflict of interest. I'm proud to have bicameral support on many of these bills from courageous leaders like Representatives Lance Gooden, Madison Cawthorn, Burgess Owens, Victoria Spartz, and Chip Roy. Conservatives are working through a paradigm shift in antitrust law, and I urge all of you to examine these bills in the context of big tech's anti-competitive practices. We can't eliminate monopoly power through Section 230 alone. The legislation my colleagues and I have proposed is necessary, targeted, and will finally hold big tech accountable. Thank you.
Thanks for having me. As we confront the challenges that big tech poses to America's economy, our discourse, our way of life, I don't think there's any need for me to dwell on the countless examples of the censorship of dissenting voices, as well as the freezing effect that it's had on political speech. You know the issue very well. So today I want to talk solutions. How do we solve this? Specifically, I want to talk about my plan to reform Section 230 of the Communications Decency Act. When it was first conceived, Section 230 was designed to enable internet companies to host third-party content and to engage in targeted moderation of the worst content without being treated as publishers, which are generally held accountable for that content. But since the bill's passage 25 years ago, the once scrappy internet companies that benefited from Section 230 protections, now they're monopolistic Goliaths. Today, Section 230 gives these companies immunity from nearly all liability, a benefit no other industry enjoys. And their mission has changed as well. They're no longer the neutral bulletin boards of the past. Today, these tech giants employ complex algorithms and teams of moderators to manipulate America's new public square to their worldview. It's clear that companies like Twitter and Facebook play the role of publisher, speaker, political activist, and I think they need to be treated as such. We can no longer accept a legal framework in which openly biased gatekeepers of the public square are now immune to any legal consequences. So that's why I introduced legislation meant to end these exemptions that incentivize corporations to act against the common good and free speech. It's called the Discourse Act, and it would modernize and limit the immunity granted by Section 230 to tech firms that comply with existing obligations to inform users of screening options and parental controls. Currently, companies routinely ignore these modest requirements while taking full advantage of the protections. My bill would also drop the vague, subjective language that has allowed tech firms to bend the rules, as proposed by the Department of Justice under Attorney General William Barr. Section 230(c)(2) provides immunity from civil liability to big tech platforms as long as they do not engage in publishing of content. However, they are allowed to moderate and to amplify content posted on their platforms, and they still have full liability protection. One justification for moderation, or as we've seen recently, censoring certain speech, is if the content is, quote, otherwise objectionable, unquote. Well, my bill would replace that vague language with concrete categories, including promoting terrorism and unlawful content. My legislation also includes a religious liberty clause stating explicitly that Section 230 doesn't extend liability protection to decisions that restrict content because of its religious nature. And more importantly, my bill would broaden the scope of practices that make a company liable for the content on their platform. My bill would remove protections for firms that engage in the following three manipulative practices. First, engaging in algorithmic amplification to target users who have not requested or searched for the content. Second, engaging in moderation activity that promotes or censors a discernible viewpoint, like demonetizing a YouTube channel because of its political lean. And finally, it would make providers responsible for information creation and development, including when they solicit, comment on, fund, contribute to, and modify information provided by another person. We've all seen the bizarre editorializing on the Twitter sidebar as the company seeks to demonize viral stories about conservatives. If a company establishes a pattern of these behaviors, it would become liable for all of the content on the site. The bottom line is that when a major tech firm engages in systematically biased content moderation or algorithm amplification, it's no longer acting as an impartial host of its content. By pressing its thumb on the scale, it clearly has a hand in developing the content. And my Discourse Act would ensure that our laws finally reflect that common sense distinction. Americans, they should be able to make informed choices for themselves and for their families. For that reason, my Discourse Act would force providers to issue public disclosures related to content moderation, promotion, and curation. Look, this is a dangerous moment for America, at which big tech has assumed what are essentially authoritarian governmental powers, the power to decide what views you're allowed to see, what you're allowed to post, and with whom you're allowed to share it with. And policymakers made it possible by giving these big tech companies near complete immunity from civil liability. Think about it, a group of unelected, anonymous, and unaccountable people. They now have the power to determine what can and can't be said in today's public square. And it's our job as policymakers to hold big tech accountable because no one else is going to do it. Our democracy depends on it. Thank you.
Hello, and thank you for inviting me to speak today. I want to say at the outset that I'm so encouraged that the Ethics and Public Policy Center has launched its Big Tech project. Holding big tech accountable for its behavior is essential to protecting our social fabric and American self-governance. In 1996, Congress wisely pursued a light touch regulatory framework for the internet, which created incredible opportunities for free speech and innovation. But with the countless benefits of the internet have come many evils and challenges, like the spread of pornographic content accessible to people of all ages, the trafficking of women and young children, and now increasing censorship by big tech companies of conservative viewpoints. For conservatives, our strong belief in free speech means that big tech censorship strikes us at our very core. Like so many of you, I believe our country is better off when Americans can engage in open, honest, and informed debate about our society. And for better or for worse, social media sites have become a common tool for Americans' engagement in public discourse. Of course, we know the First Amendment protects us against government actions that abridge freedom of speech, and not against actions undertaken by private parties. But nonetheless, as conservatives, we still question why and how this could be happening. Certainly, the American public does not want to be silenced. So why hasn't the market corrected? There are two possible explanations that I'd like to discuss today. The first is that big tech has deceived its consumers, the American people. How often do we hear tech CEOs defiantly claiming that they allow free expression and that they don't censor political viewpoints? Jack Dorsey from Twitter testified to Congress that Twitter doesn't, quote, consider political viewpoints, perspectives, or party affiliation in any of our policies or enforcement decisions, period. Close quote. Such a statement is laughable on its face, and yet he says this to his own consumers and then continues to police his own platform trolling for any conservative who would dare to challenge or question a liberal position. To address this very problem, I've proposed the Promoting Responsibility over Moderation in the Social Media Environment, or PROMISE Act, which is designed to hold tech companies accountable to the promises that they make. Essentially, under my bill, social media platforms would be required to implement and disclose the details of their content moderation policy to their consumers. Then, if these tech CEOs say anything to the public or take actions that deviate from the company's written content moderation policies, they would have committed a deceptive trade practice, actionable under Section 5 of the Federal Trade Commission Act. The second problem we face in the realm of antitrust law and policy is also worth considering here. The magnitude of the threat from big tech is directly tied to the magnitude of the firm's market power. Google, Facebook, Amazon, Apple, and others are able to get away with their blatant censorship and discrimination because there's little or no risk that we'll abandon their platforms for competing alternatives. And that's because there simply aren't any. When new platforms try to compete, they're either acquired or silenced. Companies with market power buying up their competitors and squashing competition is exactly what our antitrust laws were meant to prevent. So what went wrong? When it comes to big tech, I think a lot of the blame falls on antitrust enforcement leaders during the Obama administration. But that's not to say that there's no room for improvement in our antitrust laws themselves. And to that end, I just recently introduced the Tougher Enforcement Against Monopolists Act, or TEAM Act, along with Senator Chuck Grassley from Iowa. The TEAM Act would strengthen antitrust enforcement by consolidating enforcement at just one agency, the Department of Justice, and end duplicative efforts at the Federal Trade Commission, the other agency that has a much worse track record. The TEAM Act would also roughly double funding for antitrust enforcement and make a series of improvements to the legal standards and available remedies under the antitrust laws. For example, the TEAM Act includes a provision requiring courts to find that conduct or a merger is anti-competitive where there is direct evidence of a clear intent to harm or prevent competition. When Mark Zuckerberg writes in an email that Facebook needs to buy Instagram because Instagram is going to threaten Facebook's core business, there's no reason to bring in economists to try to explain what would really happen. When a monopolist says that he wants to harm competition, we should take him at his word and prevent it from happening. The TEAM Act also codifies the consumer welfare standard to ensure that the antitrust laws will not be politicized to pursue woke social policy, but will instead continue to focus on the economic effects on actual consumers. In addition, the bill narrows the types of evidence that antitrust defendants can rely upon to justify potentially anti-competitive conduct, requiring that any benefit or efficiency be tied to the market and conduct at issue, be quantifiable, have a high likelihood of being achieved, and actually benefit consumers and not just the company's bottom line. Finally, the TEAM Act allows the government to recover treble damages on behalf of consumers, imposes hefty civil fines for knowing violations of the antitrust laws, and prohibits awarding federal contracts to companies that violate the antitrust laws. There are many more provisions in this bill, all of which I believe serve to strengthen and improve antitrust enforcement, to give us the best possible chance of avoiding the mistakes of the past that allowed big tech to amass so much market power through anti-competitive conduct and serial acquisitions. Our goal here should be to restore fair and free markets for conservatives and liberals alike, so that we can get back to competing in the marketplace of ideas as vigorously as businesses compete in the marketplace for goods and services. Thank you for your time, and I look forward to conversations to come.